Hi everyone, my name is Ramana Reddy and I'm a lawyer from Hyderabad. Today I want to talk to you about the procedure that is involved in filing a recovery of money suit. So just to simplify everything, let's take an example. Let's say for example that you manufacture or that you distribute chairs and and you sell your chairs to a particular customer. Say the bill comes to say 30 lakhs for example, and your customer is not paying you. You have repeatedly followed up with him, you've tried to call him, you've emailed him, nothing is working, he's not paying you your money. What do? Now at this stage, before we go to court even, there is some pre-court procedure that you will have to follow. The first step that is involved is you will have to issue a legal notice to your customer, telling him that, look, I sold you X number of chairs at X price at this value on this date. These chairs were delivered to you on this date, and therefore you are liable to pay me. I have been repeatedly trying to follow up with you, and you've not been paying me my money that was due. So therefore, pay me within 7 days or 15 days of receipt of this legal notice. If you fail to do so, I will go to court and I will sue you for my money. Now, at that stage, the ball is in your customer's court. Now, he can choose to issue a reply notice or he can ignore your legal notice altogether. So let's say, let's assume that he goes ahead and he issues a reply notice to you. So what would he say? He would say, look, you say that 30 lakhs is due from me, but the chairs that you allegedly sold to me, I never received them, or whatever, that they were defective in some way, and he'll try to raise some kind of a defense in the reply notice. So after you issue your legal notice, he issues his reply notice. At that stage, the pre-trial or the pre-court procedure is complete. Then you need to go to the court actually and file your complaint, which is what it is called in court. It's called a plaint, which is a short form for a complaint. I don't know why they call it a plaint and not a complaint, but it is what it is. So you go ahead and you file your plaint, and in the plaint you restate all the relevant facts. You say, on this particular, I am a company that manufactures chairs. I've been in this business for so and so years. This is my registered office. This is where it is located. And this customer approached me for purchase of chairs. I sold him these chairs on these dates. They were delivered to him. Here are copies of the invoices, the purchase order, the agreement that we signed, the delivery challenge showing that the material was delivered, copies of waybills if you have them, or acknowledgements that they have received them, or even better, if you have email communications from them saying, I owe you so much, I need more time, which is just a clear-cut admission. So all these things, if and if you need more details as to what are the documents that you have to file along with your recovery suit, or a more comprehensive discussion, just not on the procedure but on the actual substantive part of how to file a recovery suit, check out the links in the description below. That's where I have links as to how you can go about filing the recovery suit. This video is just confined to the procedure. So you file your complaint, right? Then what happens? Then what happens is the court issues something called a summons, or it issues a notice to the customer, who's also now the defendant in the suit. So it issues a notice to him, or it issues summons to him saying, look, a case has been filed against you. The court has given so and so as a date. So you appear either through yourself or through your lawyer. You come to court and you appear and you defend yourself. Now, within 120 days of receipt of the summons or the notice, there is a duty on the defendant to file his answer, which in court in India is called a written statement. Why is it called a written statement, not an answer? I have no idea, but it is called a written statement. So within 120 days of receipt of from the summons, he has to, or who was the customer has to come and file his written statement as to why he should not pay you. Or, he can dispute the transactions. He says, I have no idea who this man is. I don't know why he's coming after me. Or he may say, okay, I entered into an agreement with him for sale or purchase of chairs, but, I never got chairs, they were defective, and so on and so forth. Whatever defense that he wishes to raise, he's free to raise. Now, once he files his answer or his written statement, then what the court does is, now it has both sides of the version, like it has both versions. Or I guess before we get there, after looking at the answer, if you feel that, okay, I need to add more facts, that I want to respond to his answer or to his written statement, because, that does not accurately portray what actually happened, then you can seek permission of the court to file a rejoinder or to file a reply to his answer or to his written statement. That is again with the permission of the court, which is generally granted, but you need to make out a case as to why you should be allowed to file a reply. Now, once that is done, so you have your plaint, you have the written statement filed by the other side, and you have the reply. After these three things are done, then we come to the stage of issues. So what happens is, now that the court has all versions before it, it will frame questions, because the answers that are provided by a court or by literally anybody are dependent on the quality of questions that we ask. So the court will frame questions as to, so in this present case, the court may say, is the plaintiff company entitled to the suit money? That is an important question. That is what the whole case revolves around. Now, let's say, for example, in your case, you say that, okay, there's a third party who stood as a guarantor for the customer, and you make him a party. So the court may say, okay, is the guarantee valid? Is the guarantor liable to make payment for the dues without taking recourse to the customer? How much interest is to be paid? And these, I think you get the basic idea. They draft 4 or 5 questions which are called issues, and these issues are to be answered. These issues will determine whether you will win the case or you will lose the case, and that's how they are framed. Now, once the issues are settled, that's the language that is used. Again, I have no idea why they don't say issues are framed or whatever. But once the issues are settled, then we move on. And this is when things get interesting, because so far it's only been paperwork. You filed your complaint, he's filed his answer, you filed your rejoinder, court has framed questions. Now we go to trial. So what happens now is, now I say, let's suppose I'm a company, right? And I say this much money is due to me. So I will field somebody from my company, and I will say, okay, Mr. X, who has personal knowledge of the transaction, or if I have a legal manager, I'm going to field him. And he will file his Chief Affidavit, which basically means that he's going to file his version of what happened in the case, which is mostly a regurgitation of the plaint, but you can lead additional evidence, and you can bring out more facts if necessary, but they have to be within the confines of the complaint. You can't exceed the scope of the complaint that you filed by introducing it in evidence. So let's say that let's say that your company has a legal manager, it has some executive manager who is aware of the facts of the case. So what they're going, so he will file his Chief Affidavit saying, I supplied these chairs on X date, money was due on Y date, material was delivered on Z date, and still not delivered. I sent him reminders, I sent him emails, nothing's come forward, and you file your evidence. Now the law doesn't prescribe it, but what happens is, once you file your evidence, then the other side or your customer is entitled to cross-examine you on the papers that you filed, or basically on your version of the case. So, and that is really the heart of a civil dispute, or even a criminal dispute, or any dispute. Because if you are making allegations that somebody has not paid me, then you must open yourself up for cross-examination, from the other side. Because, I mean, there are even judgments by the Supreme Court, and in a case called Antala Sudhakar, for example, the Supreme Court has said that if you don't step into the witness box, if you don't open yourself up for cross-examination from the other side, then there will be an adverse inference that will be drawn against you, that you have something to hide. Because, in this case, if you come up for cross-examination, the customer may ask you, well, you say that goods were delivered on this date, but the documents show that they were delivered on another date. What do you say about this? Or you say that Mr. X stood as a guarantee. Have you filed any deed of guarantee? You say that these invoices are payable, but it looks like your name is not on these invoices. Somebody else's name is on the invoices. You get the idea. So the idea is that the customer will try to poke holes in your case. And because you have to open yourself up, because you're making allegations, and serious allegations of non-payment of money against somebody, and you want the court to exercise its power against somebody to take their money and give it to you. So they will try to poke holes in your case, and you open yourself up for cross-examination. Now, if they poke too many holes in your case, hopefully they won't, but if they do, then you may say, okay, I think we need to cover up some of the admissions that we've made. So let me field another witness, hopefully who will fare better. So if there's somebody else in the company, who also can do better under stress, you will field him, and you will say that I have further evidence, and that person will again file his chief affidavit, and the other side will cross-examine him again. And you can do that with 2 or 3 witnesses, or with a few witnesses. You need to provide a list to the court as to how many witnesses you want to field. And after that, you will say, okay, I think we are good here, whatever good or bad, at least I think we're done here. This is the best we can do. And you will report to the court that you want to close your evidence. Now, at that stage, what happens is now the defendant or your customer now gets a chance to lead evidence on his behalf, and he will say, the product was defective, and at the time I received the material itself, I had written on the invoices, this much, I like the whole order value was for 1 CR, out of which 30 lakhs was defective, and I've written it, look at it, it's not something that I'm making up today. And that could be his defense. So somebody from his company will file his chief affidavit stating those facts, and you now will have a chance to cross-examine his witness and poke holes in his case. And if you poke too many holes, which hopefully you will, and then the other side may field another witness, and you will try to do the same again. Now, at some point, they will also close their evidence. So once the evidence of both sides is closed, then we go for arguments. At that stage, again, both the lawyer who's appearing on your behalf and the lawyer who's appearing for the customer's behalf will come to court, and they will argue based on what? Based on the plaint or the complaint that you had filed, based on the written statement that was filed by your customer, based on any reply that was filed by you, based on the chief affidavits that were filed by you, based on the cross-examinations of your witnesses, based on the chief affidavit of the other side's witnesses, based on the cross-examination of the other side's witnesses. So all this is basically raw material. As a lawyer, this is the canvas that we paint on. And based on this material, lawyers from both sides will make their arguments and try to convince the court whether money should be paid or not be paid. And once arguments are concluded, the court will reserve the matter for judgment, and it will answer the issues that were framed at that stage. And at that point, you're going to find out whether you won the suit or lost the suit, and you have to prepare an appeal if you lost the suit, and so on and so forth. But that end-to-end, at least, is the procedure in the trial court, not before the appellate court, or at least before the trial court. For the first time when you go to court, this is the procedure that is envisaged under the Civil Procedure Code. And I hope you found this video helpful. If you have any questions or comments, please feel free to drop them in the comment section. And if you enjoy the video, please consider subscribing to my weekly newsletter where I send out updates, which the link to which you will find in the description below. Thank you for watching.